Let me ask you about another case that came along in that term, Frontiero versus Richardson, which involved the first claim of, or one of the great cases involving gender classifications, sex classifications. The court was asked to apply strict scrutiny and came very close to applying it, but did not.
Fell one vote short, as I remember.
Right. In time, you became more sympathetic to this view, although at the time you didn't join in the Frontiero opinion. And Roe versus Wade is now very much seen as a gender equality opinion for the court. Do you think this is an area in which your own thinking evolved or moved?
Professor Coe, as I remember, I joined Justice White in a separate opinion that was influenced at the time. I hope I'm thinking the correct case. We were concerned somewhat, at least we made mention of the fact that the Equal Rights Amendment was pending at the time. Maybe that was a cop-out, but he and I, or one or two others, felt that maybe that was the answer to this issue. Well, it turned out that it wasn't, of course. But the court has held short of saying something like alienage was a suspect classification and was entitled to strict scrutiny. I think the alienage case was the last time that this was said. And it's always been, never has gone beyond that. Maybe it's just as well that it hasn't, but I suppose if this case came up today and with no Equal Rights Amendment in the background, that I probably would come down joining the majority.